Hey everyone. Oh, there we go. Hi everyone. Hey there. I didn't even look. Okay. Yeah, we're good. All right. We're good. Oh, there's no one here yet. It's all right. I didn't plan this live stream. Oh, wait, why can I hear him? Shut up. Okay. I didn't plan this or anything. I didn't even know about this whole filing or whatever you want to call it until like, I don't know, a little while ago. Like right after or shortly after I get out of work. I had to work all night basically. Let me get over that. So I skimmed over this, but I don't really understand it. So if you came here looking for answers, I'm not so sure you're gonna find them here, but I'm gonna read it anyways. I'm hoping that maybe reading it more thoroughly, I'll come to understand this. But from what I read on Twitter, it sounds like that I think that so when it came to summary judgment, didn't like both sides file for that or something? I think. But in Katie's I think when it came to Katie's filing motion for summary judgment, the judge, from the sounds of it, awarded some things, but only because the things that were claimed there was no longer an active link for. In other words, like the post, whatever the defamatory social media statement was gone. So because of that, the judge granted the summary judgment for for Katie's benefit or whatever, as far as that goes. But as far as the rest of it goes, it sounds like the judge is saying like, no, this is going to trial. Like, it's very plausible that a jury would find the petitioner's claims to be accurate, so therefore it just has to go for a ruling to a jury. That's what I gather from it. I don't know. Again, I'm not a lawyer. I say this all the time. I'm not a lawyer. I'm not anything close to it. So yeah, like I don't know. I haven't even caught a case really yet, so I can't even have experience from that end. Like I know nothing about it. But I don't know. Either way though, it sounds like she's going to trial. Like, right? And she's going to try. And there were some very interesting parts though that I did kind of find when I skimmed over it. Actually, I want to look up something real quick. So I was reading something in the Discord. I want to read it real quick. And where'd it go? That wasn't it. Oh my gosh, Discord looks like it's been busy tonight. I haven't been here. I was reading it earlier, but I didn't get to see all of it. Okay, 1 second. Okay. What does that say? Oh, there. Okay, all right. Yeah, I do remember that part. Okay, so and here's what I'm going to do because I'm going to be reading and my eyesight sucks and I need my glasses, but I don't like to use my glasses with the filter and the camera I'm using because it makes things look all screwy. So I'm going to use a different filter. We're going to have fun. I'm going to have fun. I don't know. I don't know about the rest of you. So we're going to read this as a piece of broccoli. Or no, maybe not. We can do the ghost. I like the ghost, actually. I want to do the ghost. I like this ghost mostly because it looks like a full condom. It's funny. Anyway, okay. I got to stop or I'm going to just have way too much fun with this. Let me check chat real quick before I go on over there. Hi, Renal. How you been? Hi, without a lawyer. Oh, I'm right? What am I right about? So, yeah, exactly. So it is not frivolous after all. Exactly. Hi, Tax Max Fax Thunderclap. So, you need lawyer cat. My cat's around here somewhere. Actually, my cat's very happy because I moved different furniture in here, and the furniture I put in here is my cat's favorite piece of furniture because it's 2 reclining chairs, but it's like a middle thing in between the 2 chairs where, drink holders and this thing that flips up or whatever. But underneath the thing that flips up is just like this big empty hole, and that's where my cat loves to hide and sleep. So, like when we first got her, she would disappear. I didn't know where she went. So we set up the camera. And I saw her walk back in. I'm like, sorry, so she's coming from the love seat. It took me forever to find out where she was hiding. So, but she's happy. I got it. I brought it in here. Fuck you, Renelle. You're fucking with me now, aren't you? Congratulations. I'm very happy to hear that, Renelle. Renelle's going to be a grandmother again. No, I'm very happy for you. That's awesome, though. Yay. Oh, you lucky bitch. Maybe I will someday. I don't know. It's okay. Until then, I'm just going to adopt someone and have a grandkid. I don't know. But good early morning to you too, AH. Hi. All right. So that is awesome, Dora. Now I'm so happy for you. I'm totally jealous, but very happy for you. Okay. So I'm going to go head on over there. We're going to read this. I'm going to try and get through it. I do skip over some of the legal jargon because I don't know. I want to get to the drama of it, I guess. So let me present. Why is it not showing? Is it showing now? Okay, there we go. Okay, one more thing. Okay. So this is order granting in part and denying in part motions for summary judgment. Let me make sure I have the right microphone and shit on. I didn't even look. I should. And yep, okay, good. We're good. All right. The above entitled matter came on for hearing before the Honorable Carrie Willis on January 6, 2025. On the parties, both, okay, so yeah, motion for summary judgment. So it sounds like both sides did have a motion for summary judgment because that's plural possessive. So, right? Yeah, I don't know. Yes. Amber Stavik appeared on behalf of plaintiffs. Jennifer Moore appeared on behalf of defendants. So that means Amber appeared on behalf of 7M and Jennifer appeared on behalf of Katie. Plaintiffs filed exhibits 100 to 125 and defendant filed exhibits 200 through 285 through the Minnesota Digital Exhibit System. Plaintiffs' amended complaint contains 85 statements upon which their case is based. After oral argument was concluded on the parties' motions, the court created a document numbering each statement from plaintiff's complaint with plaintiff's description of the false allegations and provided a copy to the parties. On March 26, plaintiffs filed a document that matched the court's document and included links for each statement. Similarly, defendants filed separate exhibits containing the link for each statement in plaintiff's complaint. Based upon the files, records, and proceedings herein, the arguments of counsel, and review of the exhibits and the parties' memoranda, the court makes the following. 1. Findings of fact. On March 31st, plaintiff 7M Films Incorporated and Robert Shin, which are a, quote, talent management company, and its CEO and sole owner, respectively, based in the state of California, commenced this lawsuit against Catherine Paulson and Without a Crystal Ball LLC, a Minnesota resident and Minnesota corporation, respectively. Ms. Paulson runs several social media accounts with substantial reach, numbering in the tens or hundreds of thousands of followers and attendant engagement, particularly on Instagram and YouTube. Shortly thereafter, the complaint was amended to add Miranda Derrick and James Derrick as plaintiffs. The amended complaint pleads 9 causes of action. The 9th count is mislabeled as count X. The amended complaints against Ms. Paulson and her LLC, but counts 1 and 2, defamation per se, respectively, ultimately underlie the remaining counts. Plaintiffs allege that Ms. Paulson, via her Instagram page and other social media, defamed plaintiffs by posting false statements about 7M and associated individuals. The remaining counts are for tortious interference of contract, count 3, commercial defamation, count 4, intentional infliction of emotional distress, count 5, negligence per se, count 6, deceptive trade practices, count 7, intentional interference with prospective advantage, count 8, and injunctive relief, counts 10. Okay. Well, where's so? All right, never mind. I think it mislabeled as count X. Okay. Plaintiff's business is in the field of social media communications and marketing, as well as brokering deals between performers, particularly dancers and commercial venues. Defendant, in her social media posts, as listed by plaintiffs, claims that plaintiffs, in addition to their commercial ventures, are involved with Shekinah Church, where plaintiffs claim that defendant characterizes as a cult. Defendant has also made allegations that plaintiff and other dancers have little to no control over their content, living arrangements, or finances. Plaintiffs argue that all of defendants' claims are false and have resulted in plaintiffs' reputation and standing in the community being irreparably harmed. I can't talk tonight. In his deposition, Robert Shin testified that the spiritual meaning behind 7M is that God created the heavens and the earth in 7 days, and that it is not associated with the 7 mountains of influence as suggested by defendant. Mr. Shin also testified that 7M does not provide the dancers wardrobes and that not all dancers are members of Shekinah Church. Additionally, he indicated that 7M does not impose consequences if church members miss church, that no one from Shekinah writes checks for dancers from their personal accounts, and that he is unaware of anyone from 7M writing checks for dancers from the dancers' personal bank accounts. He denies that the dancers are living under tight control and are forbidden to do anything without the permission of him or one of his associates. He also claimed that he never made any suggestion to the dancers regarding the 10-10-10 arrangement, 10% tithing, 10% offering, 10% to the man of God. He further testified that he believes there is evidence of defendant contacting 7M's sponsors, including Forever 21, advising the 7M is a cult and they should not work with 7M. Mr. Shin claims that the dancers have left 7M because of the defamation and hostility created by defendant and her followers, and that 7M has suffered financial losses due to their departure. 5. In her deposition, Miranda Derrick testified that defendant has interfered with her business by reaching out to brand deals with which Ms. Derrick was collaborating and telling them not to associate or work with Ms. Derrick. Ms. Derrick claims that defendant has falsely stated that Ms. Derrick is a victim, that she does not run her own financial accounts, that she gives all of her money to her pastor in church, that she does not speak to her family, that she only wears gifted clothes, and that she is associated with a cult. Ms. Derrick indicated that no one at 7M or Shekinah Church has ever asked her to sign blank checks. She claimed that she provides her own wardrobe and that Mr. Shin only made recommendations about music. Ms. Derrick maintained that she has consistently lost income in brand collaborations since defendant began covering the plaintiffs, including Sutter Home Wine, Stronger, Keto, an athletic company, and a travel company. In his deposition, James Derrick stated that Ms. Paulson interfered with the brand contract plaintiffs had with the Clippers, and he has earned less since defendant started reporting on him. In her deposition, Ms. Paulson testified that she has a YouTube channel, a Facebook page, Instagram, Threads, TikTok, and Twitter. She said she believes the Derricks are lying about not being controlled by the Shins via 7M because, quote, they both appeared incredibly coached. Ms. Paulson stated that she based her accusations against Mr. Shin and 7M regarding financial control and SA based on the testimony of individuals influenced and harmed by Mr. Shin. However, she was unable to point to any specific testimony. You don't say. Ms. Paulson explained that she based her reporting on Ms. Derrick being taken advantage of on information provided by other individuals. She further indicated that at the time, she reported that the Derricks were not married. She did not know if they were married or not. Ms. Paulson stated that she has encouraged people to boycott plaintiffs and their social media, and she has shared information regarding companies who canceled contracts with plaintiffs. Ms. Paulson stated that she based her reports that Mr. Shin, 7M Shekinah Church, groomed individuals based on public statements made by other people. Plaintiff's amended complaint contains 85 statements that they describe as false allegations to support their claims. Some of the statements either do not have a link or they contain a statement that the post has been removed. See statement numbers 12, 21, 31, 39, 40, 42, 46. Okay, you get the point. Seeing as the court was not able to independently review these posts, it cannot be said whether or not there is a genuine issue of material fact as to whether they are defamatory, and it is appropriate to grant defendants' motion for summary judgment in regard to those statements. So that's what I was saying before. Like, if the court couldn't, if the link was broken or just a dead link, then the court can't view it, so the court can't rule on it. So therefore, they have to dismiss it, and that's what happened. It looks like. For those, anyways. There's a lot more, though, left. In several of Ms. Paulson's posts regarding plaintiffs, she includes hashtags such as cult, free Miranda, 7 mountains of influence, free Miranda Derrick, trafficking, forced labor, true crime, facts, false prophets everywhere, false prophets Muhammad, human trafficking, trafficking. All these hashtags were made in reference to one or all of the plaintiffs. See, look at all these statements that are left. In one of her posts, Ms. Paulson stated the 7M is likely associated with the 7 mountains of influence, which she describes as a, quote, damaging and anti-biblical movement that has taken a hold of Pentecostal churches. Mr. Shin stated in his deposition the 7M is not related to the 7 mountains of influence. Many of defendants' posts mention that Ms. Derrick has been lured into a church that tightly controls their members, and that Ms. Derrick has been groomed, abducted, and brainwashed. Several of the posts also categorize Ms. Derrick and Mr. Derrick as victims of 7M, claim Ms. Derrick does not have a car or home registered in her name, and state Mr. Shin and other associates of 7M are forcing her to have little to no contact with her family. Ms. Derrick denied all of these claims in her deposition. Ms. Paulson reached out to MAC Cosmetics to determine if they had a branding deal with Ms. Derrick and to inform them that it appeared Ms. Derrick was falsely advertising that she was working with MAC Cosmetics. Additionally, Ms. Paulson took a screenshot of Mr. Derrick's Instagram story where he tagged Forever 21 for advertising purposes. Ms. Paulson posted the screenshot to her Instagram account with the text over Mr. Derrick's page stating, quote, Internet, do your thing. Ms. Paulson's other captions and reels refer to 7M luring dances, I think that means dancers, with unfilled promises, forcing dancers to isolate from their family, ostracizing dancers who refuse to submit to the church agenda, and holding the dancers captive. The post also contained various statements that 7M is controlling the dancers' schedules, time, activities, wardrobe, music, body weights, and finances. She additionally claims the dancers' social media is controlled, curated. Why can I cannot say that word. Something about the UR I have always had a hard time saying. And fake, and that dancers are constantly and forcefully worked by 7M for the sole benefit of Mr. Shin and his associates. In addition to her written captions, Ms. Paulson recorded several Instagram live videos in which she states that 7M is luring in dancers and likely engaging in human T-word. And Ms. Derrick is not allowed to speak to anyone or be left alone and does not drive, and that the dancers are highly monitored by management and isolated from their friends and families. She compared 7M to a Jim Jones cult and accused 7M of T-word and forced labor. In both her live reels and her Instagram captions, she characterized 7M as, quote, predatory, and stated that dancers are not getting paid a fair wage and are in a cycle of being trapped in a cult where every aspect of their life is dedicated and controlled. Ms. Paulson called into question the Derricks' marriage and stated that she thinks all the dancers' marriages are fake. The Derricks are, in fact, married. Defendant also claimed that 7M deleted the Derricks' Facebook page or profile and Mr. Derrick's Twitter, while Mr. and Mrs. Derricks state they have control over their social media accounts. Well, let me check chat real quick. I haven't checked it in a minute. That is a good question without a lawyer. If KJ loses, I wonder if Netflix has to put a disclaimer on the documentary. I would wonder that too. Oh, I got all sucked up into the Kara retrial too. Yep. Yep. Dude, like some of the best fucking TV I've ever seen, though. I know it wasn't TV, but it was kind of TV, and it was the best TV I've ever seen, I think. Some parts of both trials was just like, holy shit. Okay. Okay. Ms. Paulson stated that 7 is preying and exploiting black dancers and, quote, making black dancers believe that everyone is mad at them because they're black. I remember that. Oh my God, I read them like this. People are mad at them because they're black. What is she saying? Ms. Paulson posted about contacting the LA Clippers regarding the information she said she covered about 7M, and she claimed victory. 7M's performances were immediately and in Clippers. Ms. Paulson stated Mr. Shin is, quote, using the church shell nonprofit to defraud people and enrich himself by funneling donations to shell for-profit companies, which she compared to a money laundering scheme. Conclusions of law. Quote, a party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. Summary judgment shall be entered if the movement shows that there is no genuine issue as to any material fact, and the movement is entitled to judgment as a matter of law. A party asserting that there is no genuine issue as to any material fact must support the assertion by 1, citing to particular part of the materials in the record, including depositions, documents, electronically stored information, affidavits, stipulations, including those made for purposes of the motion only, admissions, interrogatory answers, and other materials, or 2, showing that the materials cited do not establish the absence or presence of a genuine issue for trial, or that an adverse party cannot produce admissible evidence to support the fact. The moving party bears the burden of demonstrating the non-existence of any genuine issues of fact. When reviewing a motion for summary judgment, the court must view all facts in the light most favorable to the non-moving party and construe all inferences against the moving party. A court deciding a summary judgment motion must not make factual findings or otherwise weigh the evidence. The district court determines whether genuine factual issues exist. A genuine issue is one the parties reasonably dispute. A material fact is one of such a nature as will affect the result or outcome of the case depending on its resolution. When a moving party has carried its burden, the non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. The non-moving party must offer significant probative evidence tending to support its position. If there is any doubt as to the existence of a genuine issue of material fact, the doubt must be resolved in favor of finding a fact issue exists. In considering a motion for summary judgment, the inquiry is whether there is any genuine issue of material fact, not how any such issue should be resolved. Count 1, defamation. The elements of defamation require the plaintiff to prove that 1, the defamatory statement was communicated to someone other than the plaintiff. 2, the statement is false. 3, the statement tends to harm the plaintiff's reputation and to lower the plaintiff in the estimation of the community. And 4, the recipient of the false statement reasonably understands it to refer to a specific individual. Okay. Truth is a complete defense to a defamation action, and true statements, however disparaging, are not actionable. As a general rule, the truth or falsity of a statement is a question for the jury. Statements of pure opinion are protected under the First Amendment. Whether a defamatory meaning is conveyed is dependent upon how an ordinary person understands the language used in the light of surrounding circumstances. In deciding whether words bear a non-actionable meaning, the words must be construed as a whole without taking any word or phrase out of context or placing undue emphasis upon any one part. Epithets or adjectives can constitute defamation if they imply a specific type of reprehensible conduct. If the plaintiff is a public figure, the plaintiff must prove that the defendant acted with actual malice. Actual malice is shown only by proof of defendant's actual knowledge of falsity or reckless disregard for the truth or falsity of his publication. Reckless disregard for the truth is a subjective standard. The Supreme Court has held the following regarding summary judgment and the actual malice standard. All right. I'm not going to go through and read that. Okay. While plaintiffs do not address whether or not they are public figures, they seem to concede that the actual malice standard applies to this case because they argue that they have satisfied the actual malice standard in their pleadings and make no mention of common law malice. Turning to the elements of defamation, the first element is satisfied as plaintiffs have proven that the statements were communicated to someone other than the plaintiffs. Defendant undisputably made the statements at issue on a social media platform that was disseminated to a significant number of people other than plaintiffs. Second, there are several disputed factual issues regarding whether the statements were false or were made by defendant with reckless disregard of their truth or falsity. In the depositions of Mr. Shin, Mrs. Derrick, and Mr. Derrick, they dispute all of the statements made by Ms. Paulson in her various posts, including the meaning of 7M, the amount of control exerted by 7M and Mr. Shin over the Derricks and other dancers, and that Mr. Shin and 7M were engaging in forced labor and trafficking. The truth or falsity of these statements is a question for the jury. Ms. Paulson argues that the statements made by her regarding the plaintiffs are her opinion and therefore do not qualify as defamation. However, the court carefully reviewed all of plaintiffs' videos and captions and does not find that they are all rooted in opinion. While Ms. Paulson occasionally claims in her post that the information provided in her post are her opinion or are based on other people's allegations, she usually follows up those posts with hashtags referring to trafficking, human trafficking, ST word, cults, and forced labor. These posts must be construed as a whole. When looking at each post as a whole, a reasonable jury could find that Ms. Paulson acted with actual malice. Ms. Paulson also argues that her statements referring to 7M as a cult is protected under the, I don't know how to pronounce that, ecclesiastical, abstention doctrine, which protects doctrinal statements as to whether a church is a cult. However, Shekinah Church is not a party to this proceeding. In this case, Ms. Paulson is referring to 7M being a cult, and such statements would not be protected under that abstention doctrine. Furthermore, a reasonable jury could find that describing 7M as a cult could imply a specific type of reprehensible conduct. Third, a genuine issue of fact also exists as to whether these allegations could harm plaintiffs' reputation in the community and lower them in the estimation of the community. Presumably, a reasonable jury could determine that accusations of forced labor, human T-word, and cult-like behavior could harm one's reputation and estimation in the community. Fourth, it is undisputed that all of Ms. Paulson's posts clearly refer to one or more plaintiffs either by her direct statements or the hashtags included with her posts. Because a genuine issue of material facts exists as to whether Ms. Paulson acted with actual malice, as such, summary judgment is not appropriate on count 1. Count 2, defamation per se. Damages are presumed in cases of defamation per se. Okay. Courts allow presumed damages because statements that are defamatory per se are virtually certain to cause serious injury to reputation, and this kind of injury is extremely difficult to prove. 1 second. Okay, sorry, I had to do something quick. And oh shit! Oh, thank God! Oh my God, I thought I unplugged something like important. Where the hell did it go? Great. All right. I don't know where it went. I'll find it later. Okay. Let me check chat while I stop there for a second. Hi, Jill B. Hi, D. Jones. Hi, Animal Lover. Hi, Amy C. Amy, see you later. Hi, Scrummy Mummy. Hi, Mimi G. You're at your daughter's helping with your 4th grandbaby, a boy. All 4 are 2 under. Oh my God. Are 2 and under. Oh my God. Like I had 2 that were like 2 and under, and that was too much. Most days it was too much. Wow. Well, congratulations. That sounds fucking awesome, though. Okay. All right. So here we go back. Did I just read that? Okay. Damages. Stop it. Damages are presumed in cases of defamation per se. Courts allow presumed damages because statements that are defamatory per se are virtually certain to cause serious injury to reputation, and this kind of injury is extremely difficult to prove. Courts have recognized statements such as false accusations of committing a crime and false statements about a person's business, trade, or professional conduct to qualify as defamation per se. However, damages cannot be presumed, and a showing of actual harm to reputation is required where the defamatory statements were made by the media, involved a matter of public concern, and there have been allegations of actual malice. The determination of whether speech involves a matter of public or private concern is based on the totality of the circumstances, and courts should consider the content, form, and context of the speech. While the media versus non-media defendant distinction is not in and of itself determinative as to whether a private defamation plaintiff must establish actual harm to reputation in Minnesota, the distinction may have relevance in analyzing whether the challenged statements involve a matter of public concern. Speech deals with matters of public concern when the speech relates to a subject of legitimate news interest. Accordingly, courts may consider decimation of the statements in the news media as one of many relevant factors in determining whether the statements involve a matter of public concern. See, and here's where I kind of have an issue with this. Robert Shin, none of these answers, none of that was of any public concern until she just like catapulted it right into the public and made it be of concern. So I don't know. That's my take on it, but whatever. Stating media coverage. Okay. The court finds that Ms. Paulson's statements regarding plaintiffs were a matter of public concern as there was a legitimate news interest in plaintiffs. Yeah, there was, because she fucking made their become one. She created the interest. Okay. All right. I digress. There was significant media coverage involving plaintiffs, including a Netflix documentary and other articles in publications such as Rolling Stone and the New York Post. Yeah, because she fucking made that possible. The court further finds that there is a genuine issue of material fact whether Ms. Paulson acted with actual malice in making her statements, as discussed in detail in count 1. Because there is a disputed issue of material fact regarding whether Ms. Paulson acted with actual malice, damages cannot be presumed at this stage in the litigation, and summary judgment is not appropriate on count 2. Count 3, tortious interference of contract. The elements of wrongful interference with a contractual relationship are the existence of a contract, the alleged wrongdoer's knowledge of the contract, intentional procurement of its breach, without justification and damages. Ordinarily, whether interference is justified is an issue of fact, and the test is what is reasonable conduct under the circumstances. First, plaintiff testified that they had sponsorships and or contracts with such companies as Sutter Home Wine, Stronger, Keto, Forever 21, and the LA Clippers. Second, clearly, Ms. Paulson knew of these contracts, as some of her posts referred to plaintiff's involvement with Sutter Home Wine, Forever 21, and the LA Clippers. Third, Ms. Paulson intentionally posted content which referred to her contacting the Clippers regarding plaintiffs, and another post where she stated, quote, "Internet, do your thing," regarding plaintiff's partnership with Forever 21. Ms. Derrick also testified that she is aware that Ms. Paulson contacted brands with whom Ms. Derrick worked. Fourth, whether Ms. Paulson alleged interference was justified is a factual issue to be decided by the jury. Fifth, plaintiff stated they have suffered loss of income since defendant allegedly interfered with their contracts. As there are disputed issues of material fact regarding whether Ms. Paulson wrongfully interfered with plaintiff's contractual relationships, summary judgment is not warranted on count 3. Commercial defamation. If the defamation affects the plaintiff in his business, trade, profession, office, or calling, it is defamation per se and thus actionable without any proof of actual damages. A jury could reasonably conclude that the alleged defamation did affect the plaintiff's business, trade, profession, office, or calling. For example, Mr. Shin testified in his deposition that 7M is now defunct and has no clients. Similarly, both Ms. Derrick and Mr. Derrick testified that they earned less income and gained less sponsors incrementally as defendant began posting about plaintiffs. Because counts 1 and 2 underlie plaintiff's commercial defamation claim, and the court finds there are disputed issues of material fact regarding those counts, summary judgment is not warranted on count 4. In determining negligence per se, in determining whether a violation of a statute constitutes negligence per se, a plaintiff must demonstrate that 1, the breach of the statute harmed persons intended to be protected by the statute, and 2, the harm suffered is the type of harm the legislature intended to prevent. Plaintiffs rest their negligence per se claim on the criminal defamation statute. The statute states, defamatory matter is anything which exposes a person or group, class, or association to hatred, contempt, ridicule, degradation, or disgrace in society, or injury to business or occupation. Subdivision 2X constituting whoever with knowledge of its false and defamatory character orally, in writing, or by any other means communicates any false and defamatory matter to a third person without the consent of the person defamed is guilty of criminal defamation and may be sentenced to imprisonment for not more than 364 days or to payment of a fine of not more than $3,000 or both. Subdivision 3, justification. Violation of subdivision 2 is justified if 1, the communication is absolutely privileged, or 2, the communication consists of fair comment made in good faith with respect to persons participating in matters of public concern, or 3, the communication consists of a fair and true report or a fair summary of any judicial, legislative, or other public or official proceedings, or 4, the communication is between persons each having an interest or duty with respect to the subject matter of the communication and is made with intent to further such interest or duty. And subdivision 4, testimony required. No person shall be convicted on the basis of an oral communication of defamatory matter except upon the testimony of at least 2 other persons that they heard and understood the oral statement as defamatory, or upon a plea of guilty. All right, let me check chat here real quick. I'm listening. Is this it, or is this it? Is this karma come calling? Well, I don't know. Like I started the stream off saying I'm not a lawyer, and I'm not sure I really understand all of what I'm reading, but the impression I'm getting is that Katie tried to get all of their gripes or whatever, their complaints dismissed through summary judgment motion or whatever. And the judge only partially granted it only because on the claims that Katie wanted to see this dismissed or whatever on, there were some claims where the link was no longer valid. It didn't lead back to the actual post or whatever. So the court could not independently review the statements or the posts that applied to Katie's social media for some of them. So the court went ahead and granted the summary judgment for those complaints. But there was maybe a third of all the complaints in total from the looks of it. So there's a hell of a lot more that are still in play here throughout this lawsuit. And from what I'm gathering, from what I'm reading, it's the judge is saying that there's no definitive evidence to state these claims one way or the other. Therefore, it should be left up to a jury to decide. And on several of them, the judge has gone so far as to say, judging by what has been presented, it's reasonable to assume that a jury would in fact find the plaintiff's complaints here validated. So that's what I'm getting at it. Anyways, if you want to know an actual definite answer to your question, don't ask me because I'm not a lawyer. I don't know, but that's what I'm guessing. And it does sound like that there's going to be some sort of trial. At least at this point, that's the intention anyways. That's the intention of the court and the judge for that matter. So yeah. I can't imagine that's going to make her happy. Okay. Defendants argue that plaintiff's negligence per se claim must fail because the underlying statute was deemed unconstitutional in State v. Turner. Defendants are correct that the Turner case held that the criminal defamation statute was unconstitutional because it was overbroad and that it failed to narrow the definition of criminal liability to only false statements. However, the statute was amended after the Turner case to reflect that the person communicating the false and defamatory matter must have knowledge that it is false, as the current version of Minnesota statute has not been held to be unconstitutional. Plaintiffs can proceed with their negligence per se claim. A jury could reasonably find that plaintiffs are the type of persons intended to be protected by the statute, as they claim Ms. Paulson's posts exposed them to contempt and degradation in society, resulting in injury to their business. A reasonable jury could also determine the legislature intended to prevent this type of behavior by enacting the statute. Furthermore, there are several issues of material fact as to whether defendants' reporting on plaintiffs was justified, such as if the communications were fair and made in good faith with persons participating in matters of public concern. As such, summary judgment is not warranted on count 6. Count 7, deceptive trade practices. A person engages in a deceptive trade practice when, in the course of the business, vocation, or occupation, the person disparages the goods, services, or business by false or misleading representation of fact. Okay. An action to recover for a false or misleading statement or report differs significantly from an action for defamation where there is a presumption that the disparaging statement is false. The burden is on the plaintiff to prove that the statements are false. Defendants' statements regarding the T-word, forced labor, cult-like behavior, and strict control and isolation of dancers could all be considered disparaging 7 on Mr. Shin and the Derricks. The resolution of this claim will rest on whether or not the jury finds the statements were false. As such, summary judgment is not warranted on this count. Count 8, intentional interference with prospective advantage. There are 5 elements to a claim of tortious interference with a prospective business advantage. 1, the existence of a reasonable expectation of economic advantage. 2, defendant's knowledge of that expectation of economic advantage. 3, the defendant intentionally interfered with plaintiff's reasonable expectation of economic advantage, and the intentional interference is either independently tortious or in violation of a state or federal statute or regulation. 4, that in the absence of the wrongful act of defendant, it is reasonably probable that plaintiff would have realized his economic advantage or benefit. And 5, the plaintiff sustained damages. The plaintiff has the burden to demonstrate the existence of a reasonable expectation of an economic advantage. To that end, a plaintiff must specifically identify a third party with whom the plaintiff had a reasonable probability of a future economic relationship. Thus, a plaintiff's projection of future business with unidentified customers without more is insufficient as a matter of law. Furthermore, general damage to the plaintiff's reputation is insufficient to establish that an expectation of economic advantage was damaged. First, a jury could find that plaintiffs had a reasonable probability of future economic relationships based on their previous contracts and sponsorships and the fact that they had a substantial number of followers. They specifically identify such current and potential clients as the LA Clippers, Forever 21, and MAC Cosmetics. Second, Ms. Paulson clearly knew about plaintiff's economic expectations with these clients, as she would post about ongoing or potential relationships plaintiffs had with other sponsors. Third, a jury could reasonably find that Ms. Paulson intentionally interfered with these potential contracts, as indicated by her post regarding MAC Cosmetics and the LA Clippers. Fourth, a jury could conclude that it is reasonably probable that plaintiffs would have realized an economic advantage on these contracts based on their extensive social media presence and their history of significant earnings from their branding. Fifth, plaintiffs stated that they have made less money every year since Ms. Paulson's postings than the year prior. A jury could reasonably determine that loss is a result of Ms. Paulson's intentional interference. As such, summary judgment is not warranted on this count. Order. It is hereby ordered. Plaintiff's motion for summary judgment is denied. Defendant's motion for summary judgment is granted with respect to statements as numbered follow. Defendant's motion for summary judgment is denied in all other respects. Any discovery disputes shall be brought via separate motion. Okay, and there's, yeah. So that's it. That's all of it. Oh shit, what am I doing? Get off there. Okay. All right. Wait a second. Okay, no, I don't have to move. Sorry. Let me go back to chat here. Yeah, I was reading as it goes because I had to put my glasses on to read. Otherwise, it would have been horrible. So, and I don't care how I look at my glasses, but it messes with the camera and shit. I don't like it. Wonder if Graham will rant at Walgreens tomorrow. I don't. What does that mean? Wonder if Graham will rant at Walgreens tomorrow. Her old attorney. Wait, I get confused now. What's right? Okay, never mind. I think I know. Yeah. So that's it. That's it. Let's see here. Okay. All right. So, all right. I'm tired. Oh, I worked last night. I worked tonight. I gotta go back in tomorrow. And tomorrow's my long day. But then I get the next 2 days off. Yay. Let me close these out and let me see what's going on over here. Oh, for fuck's sake. What? Oh shit, I forgot about that. So what do you guys think? Now, I'm curious. Here's what I want to know. This goes to trial. It's going to be open court, right? I mean, because it's court is that's how it is. I mean, it may not be open for virtual attendance, maybe, I don't know, but it's going to be open to members of the public, right? So, and not that I'm not encouraging anyone to go there. Please, for the love of God, don't misconstrue what I'm saying. But I'm just pointing out this fact, and so yeah, that would not go over well, I'm thinking, because just I recall the fits she threw over someone, I don't know, joining in on a hearing or something. But I mean, I think it's only fair, really, that it is public, because the defamation, at least the alleged defamation, anyways, absolutely happened in a public setting. So any resolution as a result of that should also happen in a public setting, should it not? I mean, it's only right. I mean, how else? Nothing's gonna be resolved otherwise. Oh shit! I didn't put this back. Sorry about that. No, okay. Petition for court TV to cover. Oh no, she didn't get a Bentley. It was a BMW, wasn't it? She just, I think she just made that comment like she could afford. She said that she could afford 2 Bentleys or some shit like that, but she didn't. I don't, to my knowledge, she didn't actually buy one. The image she posted of the new vehicle was a BMW. I believe. I think it's safe to say, though, she won't be able to afford the 2 Bentleys though anymore. Anyway, yeah, it's funny. So I want to just I want to check out her Instagram real quick, and then I'm gonna probably wrap this up. It wasn't so late I'd go swimming. It's so freaking hot up here. I'm in central upstate New York. It's so freaking hot. Tomorrow's supposed to be like the hottest day, I think. Yeah, we had a real nasty storm come in here too. Not last night, the night before. Like, I don't even know, it was like 3:30, 4 o'clock or something like that. The alarm, like everyone's device in the house just like started just doing the alarm sound like crazy. Fucking woke me right up. And we did have a tornado touchdown in a neighboring village or town or whatever, but not here where I live. Like, I don't know, 5-6 miles away maybe. Which is weird, because like I kept joking about when I went to Kansas last year about how, oh yeah, maybe I'll finally get to see a tornado, but I think I might actually have a better chance of seeing one right here at home. That's crazy. My computer is running like unbelievably slow tonight too. I restarted it. I don't know why it's doing this. I'm gonna have to go through and clean some shit up, I think. Which, ever try to clean shit up on a really slow computer? Like, you're taking steps to make it faster, but it's so slow to do the cleanup. It sucks. All right, so I'm finally on her Instagram page. It's finally loaded. And it's not completely loaded, apparently. And she's got nothing on here. Yeah, her most recent post on Instagram was Oh no, it was today. It was 3 hours ago. But it's about Blake Lively. Go figure. I'm gonna share screen. We're just gonna go through the comments real quick because you know that there's gonna be some smartass people who are dropping a comment in her normal post like, "Hey, and any good interesting motions or filings today? Any updates you want to share with the class?" Which, if you haven't done that, please don't take this as encouragement to go do that. Don't do that. Like literally, I want any actions you all may or may not take going forward to not at all be influenced by me at all. Like no influence by me, one way or the other. Okay, so oh my god, you know why Katie really feels and believes so strongly this Gladys is lying about the sexual harassment, which maybe she is. I don't know. I don't care. I'm not making an argument one way or the other. I'm just talking about Katie's aggressiveness here. I mean, no one is going to be so sure that someone is so full of shit about something based on so little unless they're speaking from experience, right? I mean, could it be that Katie Joy herself knows how full of shit she's been over these sexual harassment claims, like against Steve McRae, for example, that she feels like she's able to spot it in other people? Like that, I mean, it could be, right? I don't know. Stands to reason. Maybe not. All right, let's see. It's so crazy now to read this shit and just I can't help but to think about what it is I just read in this the court's ruling. The court is ruling that Katie Joy claims that she said these things or whatever because other people made these accusations to her. She obtained this information from other people, from testimony from someone else, what yada yada, and because of Katie's using that for an excuse and for stating these things as fact, pretty much, and over again, and defaming this, group of people's image, she's in a lawsuit. And here she is, while in that lawsuit, doing the same exact shit. Like, whatever, man. Even if you believe that Blake Lively is the most horrible person in the world, Katie Joy has no evidence or proof of any of the shit that she's stating as fact. She just has people telling her stories. And she's running with the stories as though they're fact. Oh, this is what, a day old or something? Okay. So she only made like one post maybe today? Okay. Oh my god, my computer's so slow. All right, so yeah, it doesn't look like there's anything really. I'm thinking that as a result of this ruling coming out today, that she's just maybe strategizing with her attorneys or some shit. I don't know. Yeah, this whole thing just seems so weird. Okay. Now, I'm going to say it again. The whole Blake Lively and Justin Bell doing anything is like the most entitled privilege fucking shit ever. Like, I can't even believe what both sides are suing about. This is ridiculous. Like, yeah. Anyway, that's my opinion. All right. Back over here to chat. Hi, Flying Mom Laura. It was a BMW Mercedes. Okay. Okay. I look for an appeal on her part to add more time before it's put on the docket. Yeah. Yeah, I feel for her husband, especially with everything he's faced lately. Which all I'm gonna say about that is I wish him a speedy recovery, and I hope that this is put into the past for him forever. So I feel like I shouldn't know this much though about what it is he's had to endure the past month or so. I feel like I know too much information about this. I don't want to know the information I know. You can just sit there and say, my husband's, we're going through something. He's not, or, he's going to be fine, but we have to do this big step. Like, why go into all these specifics and everything? I don't get that. It's like, I don't know, privacy just doesn't exist or isn't prioritized, in my opinion. All right, guys, I'm going to wrap this up. It's going on 2 a.m. I'm tired. And oh my God, my hair's got knots and shit in it. I got to get a brush through it. So, I'm working tomorrow. I'm not going to be streaming or anything tomorrow. But Wednesday and Thursday I have off. So look for me. I'll end up doing something. So thanks for being here, everyone. And where is it? Bye. Have a good night.